Hello everyone, I am CA Preeti Agarwal and today we are going to discuss all the RTP, MTP, study material and past exam questions from the chapter General Clauses Act. It's a very important chapter for exam and many students they don't attempt this in the exam because they're not very confident about the kind of questions that will be asked. But after watching this video you will get a very clear idea on what type of questions are asked and on which questions are frequently asked. Now this is a part of my lecture series on compiler discussion. That is, compiler is a book which contains all the past exam questions, study material, RTP, MTP questions arranged unit wise. So that book is available on my website capreetyagarwal.com, and along with the book I have a combo of lectures wherein we discuss each and every question from the compiler. So this is a part of the compiler series, but in today's session we are going to cover all the questions from the General Clauses Act. So watch this video till the end, and if you are watching my video for the first time, do leave a like button and subscribe to this channel and hit the bell icon so that you get notifications for all the important videos. For this book, that is the compiler, please visit my website capreetyagarwal.com. All right, everyone, let us discuss the questions of General Clauses Act 1897. Okay, I hope you are ready with the answers. And guys, you must have realized that not very lengthy questions are asked from this chapter. Small questions, weightage of 3 marks, 4 marks, are generally asked from this chapter. Okay, so let's get started and let us discuss our first question. What is a financial year? Now if you read the act carefully and the definitions, you will realize that the definition of a financial year is just two lines. You can't write just two lines, no, for a 3 to 4 mark question. So what you can do to increase the length is write the definition of a year. Okay, so instead of writing just what is the meaning of financial year, you can first explain what is a year. See, year means it is a calendar year from Jan to December. So what is the meaning of year? Year means, as defined in section 3, clause 66 of the act, year means a year according to the British calendar. Yes, year means year according to the British calendar, which says it begins from Jan to December, indicating that it is a period of 12 months. Now we know that year, as per our General Clauses Act, means it's the year as given under the British calendar, which begins from January and ends in December. Now what is the meaning of financial year? Financial year means the year commencing from the first day of April. Now it is a year, it means a period of 12 months. However, that period commences on first day of April. So it will be commencing from 1st April till 31st of March. This means it is a period of 12 months. Yes. So financial year shall mean a year commencing on the first day of April. The last paragraph is just a repetition of what was given earlier. In view of the above two definition, it can be concluded that financial year is a year, means a period of 12 months, but that period starts from the first day of April and it ends on 31st of March. Okay, so 1st April to 31st of March, that is a financial year. So it is an important question for exam. You need to know the provisions properly. Next, we have what is an immovable property. Again, it is one very, very important definition for exam. What is immovable property? Something which cannot be moved from one place to another. But that's not the definition given in the General Clauses Act. As per section 3 clause 26 of the General Clauses Act, immovable property, it's an inclusive definition. Inclusive means it indicates that what is included. That inclusive definition, it's not exhaustive. Okay, because yes, it does include land, benefits arising out of land, etc., but it may include something else also. The word inclusive is actually a very exhaustive, it gives a very exhaustive meaning. Okay, so land, benefits arising out of land, things attached to land, they are all included, but we may have things other than this considered as immovable property. So we have land, we have benefits arising out of land, Things attached to earth or permanently fastened, okay, permanently fastened to anything attached to earth. Now, what does it mean? Land, we are all aware of the meaning. Benefits arising out of land, this includes trees, it includes crops, okay, they are prima facie immovable. Only when you put them into baskets or bags, that time they become that time they become movable. Things attached to earth are permanently fastened to anything attached to earth. So this can be building, okay, or very heavy machinery. Very heavy machinery. Now let's say that there is a machine. Okay, this is a machine and it is chained, okay, to things which are which are permanently fastened on earth. So these are the chains, okay, and then everything is properly chained. Why? Because the machine is a very heavy machinery, it vibrates, it may move with this vibration, so we don't want it to move. So there is a commissioning, and properly we commission the machinery. So things which are attached. Now there is one difference which we need to understand, that is trees, buildings, they are immovable. However, timber, okay, timber, that is not immovable. Now what is the meaning of timber? Timber means logs, okay. See, trees, they are immovable, all right. Trees are immovable, but timber is not immovable because timber means logs. So trees, when they are cut into logs, that is timber. Timber can be moved from one place to another. So timber is not immovable property because it is not attached to earth. Building, it is immovable property. Trees are also immovable. Okay. As per the provisions of the Companies Act 2013, a whole-time key managerial personnel, a whole-time KMP, shall not hold office in more than one company except its subsidiary company at the same time. Okay, this is mentioned in section 203, subsection 3 of the Companies Act, that a KMP can be a KMP in just one company, but it can be a KMP in the subsidiary of that company. Now the confusion is, they have mentioned subsidiary company. But what if my company A Limited has three subsidiaries, S1, S2, and S3? Can this person be a KMP in more than one subsidiary? That is the confusion which we need to clear. So yes, singular includes plural also. Okay. So a whole-time key managerial personnel, a whole-time KMP, it is said, okay, the provisions say that they shall not hold office in more than one company except the subsidiary at the same time. See, you are a whole-time KMP. Whole-time KMP. Whole time means you are in whole time employment. Now, if your work timings are morning 9 to evening 7 p.m., how will you manage being a KMP of some other company? Yes, you cannot. No, it's not physically possible. But because the subsidiaries are a part of the main company itself, there is no objection to him being appointed as KMP of the subsidiary. But if I have three subsidiaries, then what should we do? In that case, yes, if you are a KMP of one subsidiary, you can be the KMP of other subsidiaries also. Singular includes plural also, and that is given in section 13 of the General Clauses Act. The word singular shall include plural also unless there is something repugnant. Repugnant means contrary to. Okay, unless there is something repugnant. Repugnant means contrary to the subject or the context. Whole-time KMP may hold office in more than one subsidiary as per the present law. So first, we discussed what exactly is the provision. Then we discussed the view of the general clauses. Like, see, here there is confusion. The confusion is created in the section. General Clauses Act is trying to provide some solution. A notice, when required under the statutory rules to be sent by registered post acknowledgement due, is instead sent by registered post. See, students, section 27 only requires the notice to be sent by registered post. So actually there is no harm in sending a registered post. But when your provision specifically mentions that you have to send it by registered post acknowledgement due, If a very specific mode is given, then you cannot say, no, 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 Act allows registered post also. How can you insist on some other post? It's clearly mentioned. So even the General Clauses Act says, first follow the Act. If there is confusion, then you prefer the General Clauses Act. Na? So whether the protection of presumption regarding the service of notice by registered post is tenable. Tenable means, is it acceptable? No, it's not acceptable. Section 27 is an important section for exam because it is a very frequently asked section in the exam, and you need to learn these provisions also. You need to learn these provisions. As per the provisions of Section 27 of the General Clauses Act, where any legislation or regulation requires the document to be served by post, okay, if it is mentioned in the regulation or the provision that you have to send the notice by post, then unless a different intention appears, we will assume that you have sent it properly, provided the address is provided correctly, you have prepaid the stamp, and you're not expecting the receiver to pay the stamp. You have paid the stamp. You are sending it by registered post. Now, a letter containing these documents will be effected. We will assume that it has reached properly as the letter would be delivered in the ordinary course of post. So if the post takes 5 days, we will assume that if the post is reaching in 5 days, then registered post will definitely reach in 5 days. Now, what is the difference between the two methods of posting? Okay, registered post and registered post acknowledgement due. In case of registered post, they will obviously take signature of the receiver. But in case of acknowledgement due, they will on a separate piece of paper take signature of the receiver and send that paper to the sender as a proof that, listen, your document has been delivered and the person has received it. See, this is his sign. So as per the provisions of Section 27, where any legislation requires you to send a notice by post, it is sufficient if you properly addresses, you properly stamp it, and it is sent by registered post. But in the mentioned case, if the statutory rules require that you have to send it by registered post acknowledgement due, then it must be sent by that mode only. If the statutory rules, they provide that the service of notice should be by registered post acknowledgement due, then even if registered post is allowed by the Act, it will not be in compliance of this rule. What if nothing was mentioned? They did not specify that you need to send it by registered post acknowledgement due. Then I think it would make no difference. You can send it by registered post in that case. However, if the provision was not provided by the statutory rules, then the service of notice by registered post only shall be deemed to be effective. So can I say that if statutory provisions, or you can say statutory rules, require service of notice by registered post acknowledgement due, okay, then it must be sent by this mode only, is valid. This mode is valid. But if nothing is specified, then simply registered post will suffice. Okay, that will be sufficient. Also, in the case of United Commercial Bank versus Bhimsen Makhija, students, please note that you need to learn the name of this case law. And if a question is asked, you need to mention the name of this case law. You have to learn the name. United Commercial Bank versus Bhimsen Makhija. Okay, United Commercial Bank versus Bhimsen Makhija. Now, in this case, a notice was required to be sent by registered post acknowledgement due, but instead it was sent by registered post only. This is not considered to be a sound understanding of law. The protection of the presumption regarding the service of notice in registered post is neither tenable nor based on sound exposition, means sound understanding of law. It is not tenable, it is not acceptable. It is not tenable, it is not acceptable. This is not a sound understanding of law. X owned 50. This is a very frequently asked question. See the number of times a question has been asked on this. Immovable property. Now, X owned 50 tamarind trees. Okay. He sold his land and timber after obtaining the cutting from the trees. He wants to know whether the sale of timber it amounts to immovable property. No, 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 no. Land is immovable, agree. Trees are also immovable. Yes, trees are also immovable. You can write here. Land is immovable. Trees are also immovable. But timber, yes, we have studied this. This is not immovable because timber is obtained after cutting the trees and it can be moved from one place to another. This is not immovable property. Okay. So land, yes, it is immovable. Benefits arising out of land. This is defined under section 3, clause 26. Here the definitions are given under clause C, clause 3. So land, benefits arising out of lands, things attached to the earth, or they are permanently fastened to anything attached to the earth, except these four. As of now, nothing is included. But inclusive definition means that temporary that as of now, as per the definition, these four elements are included, but you may include something else also. Okay, in the given case, land along with timber after obtaining the timber from cutting of trees. Okay, that land is immovable property, we agree. Timber is not immovable property, it is not attached to earth. So what did we write over here, students? First, we wrote the definition. Ma'am, what if in the exam we forget to write it's an inclusive definition, it has four elements? I agree, you will not be able to create the desired length of the answer, but then that doesn't make your answer wrong. Okay, so there are four elements. Land is immovable. You can also write trees are immovable. Because timber is obtained from tree only, right? So timber is not immovable, but trees are immovable. Meaning of service by post, section 27. It's a repeat question. It's a repeat question. A very important and a very frequently asked question. It has been asked twice, but it can be asked again also. Now, the company declares a dividend in the AGM held on 27th of September. So can I say, as soon as I start reading the question, I immediately start taking down notes. That is my habit. So the date of declaration of dividend is 27th September. Okay. The date of dividend is 27th of September. Declaration of dividend is 27th September. Advise the dates during which the company is required to pay the dividend. Now, law is very clear. As soon as the dividend is declared, you should pay, or you should at least dispatch the warrants within 30 days of declaration. Okay, so it must be paid, or at least warrants shall be dispatched within 30 days of declaration. Now, what they want you to calculate is the date by which the dividend should be paid. Okay, so what is the date by which the dividend should be paid? Now, how to calculate these 30 days? See, there are two dates. One is the from date and one is the to date. From date will start from 27 September, but law says don't include that in your calculation. The from date should not be included. The to date can be included. So now if I start calculating 30 days, okay, 30 days from 27 September, so 28, 29, 30. So I have 3 days of September and I need 30 days. So 27 days of October. So 30 days will end on 27th October 2019. I am including the to date. This is to be included in your calculation. The dates when it is required to transfer the unpaid or unclaimed dividend within 7 days from the expiry of these 30 days. Now again, I will not include 27th. My calculation will start from 28th October, then second day 29, 30 and 31st. First, second and third. Okay, so 4 plus 3, 7. So 20 8th to 30 to 3rd, both days inclusive. So this is the calculation. Now see how they have mentioned it in the answer. You, according to section 9, for the computation of time, it is sufficient if the first day in the series or any other period, that is the from date, it is okay if it is not included. Okay. And the to date shall be, included. How to calculate dividend? They have shown the calculation of 30 days. So from 28th of September till 27th of October, from 28th September to 27th October. So both days included comes to 30 days. So the due date is 27. But if you do not pay the dividend or it is not claimed, then they shall within 7 days from the expiry of the 30 days transfer the total amount to the unpaid or unclaimed dividend account. Now this account will be a separate bank account. Firstly, it will be a separate bank account. Secondly, this is a separate bank account. It is to be opened in a scheduled bank. Okay. All right. So the date will be 3rd of November. So you have to show this calculation. You have to show like how they have given it over here. You have to show the calculation. Repeal is different from deletion. See, when you repeal, it means you are removing all the traces of that act as if the act never existed. मतलब जड़ से उखाड़ देना. So repeal actually is different from deletion because repeal brings about complete obliteration. Obliteration means you're removing the provisions as if they never existed. Like if you go through the Contract Act, students, if you go through the Contract Act, section 1 to section 75, okay, these are general provisions of the Contract Act. Then section 76 to 123 related to sale of goods, this was repealed. This was covered in chapter 7. That entire chapter was repealed. Okay, also chapter, yeah, then 124 to 238, this relates to the special provision. And 239 to 266 related to partnership, this was also repealed. Also, many amendment acts are repealed because they have already brought about amendment in the original provision. What is deletion? Deletion means that you're deleting either whole or part of a provision and you can bring it up later also. Okay. We never totally wipe it out. Explain the 4 effects of repeal. This is actually a pure theory question. Section 6 talks about repeal. Okay. Now, repeal means to remove all the traces of that. To remove all that. Achha, there was one word which I wanted to give you the meaning of. Incoherent, it means not clear. Sometimes students get confused, they don't want to search the meaning also, so not clear. Section 6 of the General Clauses Act, it says that repeal shall not affect, okay? It shall not revive anything which was not enforced or prevailed during that period. See, when something was not in existence, how can repeal revive it? Something which did not exist, how can you take it back? How can you even repeal it, or how can you bring it back? It's illogical. It will not affect the prior management of the legislation. So let's say that in the previous act, people were given certain compensation, they were given certain punishment, or they were asked to do something. After the act is repealed, it will not affect whatever decisions were already taken. It will not affect any claim, privilege, responsibility, or debt obtained. It will not affect any punishment. It will not affect any penalty. It will not affect any inquiry, litigation, or remedy. So, whatever was decided, okay, whatever decisions were taken before, whatever orders were passed before repeal, they will remain the same. Now, X cannot say that I was given 7 years imprisonment, I have served 3 years. After that, the act is repealed. Now I need not serve those remaining 4 years. A penalty of 50,000 was imposed then, but before I could pay it, the act was repealed. You cannot say now I need not pay 50,000. The order was already passed. The Companies Act provides the amount of dividend which was unpaid or unclaimed on the expiry of 30 days from the date of declaration shall be transferred to an unpaid dividend account within 7 days from the expiry of those 30 days. Yeah, we agree. We just discussed. If the expiry of 30th day is on 30th of October. Okay, so on 30th October, the 30-day time period got over. Now I need to calculate 7 days. So from date will be excluded and the to date will be included. So my calculation will start from 31st of October. So 31st October, 1st November, 2nd November, 3rd November, 4th November, 5th. So this comes to 6 days, 7 days. Okay. So the time period ends on 6th of November. So I will calculate from 31st of October to 6th of November. Okay, so 31st October to 6th of November, both days inclusive. Referring the provisions of the General Clauses Act, find out the day or date on which the following act or regulation came into force. All right. An act of parliament which has not been specifically mentioned, it does not mention a particular date. Now please note the steps. Okay, this comes as an MCQ also. So if the act specifies a date, if the act specifies a date from which the act will come into force, then please consider that date only. Like, say, for example, the Securities Exchange Board of India Regulation 2015 was issued by SEBI via notification, and it was clearly mentioned that this will come into force from 1st of January. So when the date is mentioned, then yes, the act will come into force. It will commence from 1st of January rather than the notification in the official gazette. So first preference will always be given to the date specified in the act. So act specifies the date, but if there is no date specified, okay, if nothing is specified, then the date on which it receives the assent of president, date on which it receives the assent of president, okay, the date on which it receives the assent of the president. But along with that, I also have information about the date on which it was published in the official gazette. So then we will consider this date. Okay, this is the date when the president gave the consent. But we also have the date on which the notice was published in the official gazette. That is when the public came to know about it. So when the public comes to know, that is the day when we will consider that the act has been notified. So basically, the date on which the president gave his approval. If any specified date of enforcement is prescribed in the official gazette, then the act will come into force from such date. So first preference will be given to the date. Second preference will be given to the date on which the assent of president was given. Third, we will publish it in the official gazette. That date can be considered. What is a document as per the Indian Evidence Act 1872? Now, our General Clauses Act defines document by considering the definition which is given in the Indian Evidence Act. So we are considering that definition only. Now, what is a document? You must have heard that please document this, means please note it somewhere. Where? I can note it on any surface like a wall or a floor or cave walls or on a stone or on a piece of paper, floppy disk, photographs. They are all documents. Documentation means capturing text, figures, drawings, okay, because we can use it as a reference in the future. We can use it as an evidence in the court of law. So document means a paper, okay, basically it's a paper or any other material which gives information, proof, evidence of anything. Like if you go to a war memorial, now war memorial is a proof that the war had occurred. Yes, each and every detail is mentioned, when the war occurred, how many people were sacrificed, and other details. It is a proof, it is an evidence of that event happening. So yes, on any material where you are able to write. The law defines document in a more technical way. Section 3 of the Indian Evidence Act 1872 defines a document as any matter expressed or described upon substance by means of letters, figures, marks, which is intended to use, or it may be used for recording the matter. So you can use any substance for recording of that matter. So a writing is a document, words, documents, prints, photographs, they are all documents. Repeal is different from deletion. Okay, this is a repeat question. Next, we have what is the meaning of good faith. Students, if you feel that, you are getting tired or you're exhausted, you can stop the video anytime. That is the beauty of recorded lectures. You can stop me anytime you want. So if you feel bored, you can take a break because there are 30 questions. So we have almost reached the half of our discussion, but there are 30 questions. Okay, so yes, more than 30 actually. So yes, you can take a break anytime you want. Now, what is good faith? See, good faith means that my intentions were pure. Okay, I never intended to cheat the other person. I've done the act honestly. Step one. Step one. Find the definition of good faith in the respective act. Step 2. Act is silent. Then I will refer General Clauses Act. So step 1, find the definition in the respective act, like Partnership Act. Okay. If you consider the Partnership Act defines good faith. So we will use that definition. We need not use the definition which is given in the General Clauses Act because my respective act provides a definition. But what if the act is silent? Then I will refer the definition given in the General Clauses Act. The term good faith means a thing which is done honestly, whether negligently or not. Okay, I have done it honestly. Maybe I was a little negligent. Like, I went to buy a cake for my mother's birthday, but I took my scooter. I put the cake in a box, but because of the potholes, the cake got disturbed. When my mother opened the cake, and the cake was not in its original shape, that doesn't mean that she will not appreciate my effort. I did it in good faith. I was a little negligent. But see, that cannot apply in all the cases. Okay. Now, let's say, for example, that you were supposed to check certain documents before approving the purchase order. You did not check those documents. You thought everything is proper. That's not in good faith because you were required to first check that there were certain checks to be done. You did not do that. So in that case, it is not good faith. Good faith has been defined differently in different enactments. So that is my second point. Now, what is the first point that you need to write in your answer? The first point that you need to write is the definition of good faith as per the General Clauses Act. Second point says that good faith has been defined differently. So if your act is providing a definition, okay, the definition is provided, then you need not refer the definition of the General Clauses Act. The definition of good faith will not apply to that enactment which contains a special definition of good faith. Now, whether that particular act is in good faith or not, everything depends upon the facts and circumstances of the case. Like, for example, you must have seen an ad where a child is polishing his grandfather's shoe and his shirt is spoiled. Now, mother also cannot scold the child. Why? Because he was acting in good faith. He did something for his grandfather. So, yes, if it is good faith or not, that depends on the situation. So we need to refer to the circumstances of each case. Sometimes it happens when our friends tell, Are, but I never intended to do that. So, we will always determine whether the act is done in good faith or not by referring to the circumstances and facts of the case. So, good faith is determined from the facts and circumstance of the case. If the thing is done with due care, which is not mala fide, okay, it's not in bad faith, then it is in good faith. See, good faith means bona fide. And bad faith is mala fide. So if everything is in good faith, then I think we leave it over there. X purchased a watch from Y. Now that is the next sub question. Mr. X purchased a watch from Y carelessly without making any inquiry. Is it in good faith? Absolutely not. Why carelessly without proper inquiry purchase? This is not in good faith. It was done without due care and attention as a man of ordinary prudence. You cannot say, but I did innocently. I was honest. An honest purchase made carelessly without inquiries cannot be said to be in good faith. It will not convey a good title. It's not in good faith. PKVK had a long disputed battle regarding the ownership of land for which a case. This is a very frequently asked section in the exam, that is computation of time, section 10. You will be surprised to see the number of questions asked on this particular topic, section 10. You need to learn it. Now, the court had fixed a date for hearing, that is 29th of April, but on that 29th of April, the courts were closed. There was a sudden holiday declared by the court. Then the next day, following day on which the courts are open, ma'am, next day is a Sunday, then on Monday. Okay. So, whereby any legislation or regulation, act, proceeding is directed or allowed to be done or taken in the court or office on a certain date. Okay. On a certain day or within a prescribed time period. Now, let's say that I have given you a time period of 30 days. Okay. A time of 30 days is given to file a case. Now, I can file a case on the 30th day, last day also. I'm a lazy person. I went on the last day and I came to know that the courts are closed on that day. Then the case will be filed on the following day, whenever the courts are open. Okay. So, in that case, if a particular date is not given, like, I say that you have to file on 29th. On this day, the courts are closed, or I say that you need to file within 30 days. Okay, and the courts are closed on that day. Then in that case, we will assume that the act or proceeding is properly done if it is done or taken, okay, if it is done or taken on the next day afterwards on which the court is open. On the next day afterwards, next day, that is proceeding. Proceeding means next. So here we can ask them to take it up on the next day, that is 30th of April. What is the meaning of government? Okay. Income tax, it provides that gratuity will be paid to the government by the government to its employees. You are required to explain the meaning of the term government, but they have not specified whether it is state government or central government. So that is where you need to refer the General Clauses Act. Now here also the act is very ambiguous by saying that refer the context. See in which context they are using. If nothing is given, then yes, you can assume either state government or central government. Okay. So as per the definition, the government shall include both central as well as the state government. So the government will include both central as well as state government. Now here they are saying that gratuity will be paid to the government by the government to the employees. So that will include both central as well as state government. So state government employees will also be entitled. Basically, if you read the definition, they have also mentioned the word context. Okay. So you see it in the context. But if nothing is given, then yes, central government and state government both are included in the definition of government. Mr. Apar and Mr. New both are aspiring chartered accountants. They want you to tell them about the meaning of financial year. So this we discussed. It's a repeat question. Framing is different. That is why we have given it separate. Service of post also, section 27, we have already discussed. The key points are that a properly addressed, prepaid, sent by registered post, and we will assume that the document will reach when the other documents reach in ordinary course of post. What is proviso and explanation? Students, please note that in case a question is asked, it will always be asked on proviso as well as explanation. So you will be expected to write both. Now I have simplified and prepared a chart for you. I have simplified. Now, what is a proviso? Okay. Do I have some? Just a minute. Proper. You can refer my textbook. Ah, this is what I was trying to find. Yeah. So we will read this also. Okay. We will read this. Now, what is the meaning of proviso? Proviso is actually an exception. Now, provisions are mentioned over here. If the proviso is not given, it means that these provisions will apply to all the, let's say it's in the Companies Act. Okay, so this will apply to all the companies. Only through a proviso we can remove something from that provision. Now, to give you an example, now if you consider the definition of a small company given under section 2 clause 85, small company means a company other than a public company. So it means a company. So does it mean that all the types of companies are included over here? No, there is an exception. If you read the definition properly, there is an exception which is given in the end, that it will not apply to a holding or subsidiary company. It will not apply to a section 8 company. It will not apply to companies which are governed under certain separate acts, okay, which are governed by the separate acts. So the definition very clearly excludes something from the scope. This is nothing but a proviso. Acha, you must have read provided that. Okay, provided, what is it? Proviso was not there. It means that if the proviso was not there, it would apply, the provisions would apply to everyone. But from that, now, proviso is removing something which is already contained in the main section. So the main provisions contain something. We are removing it from there with the help of proviso. So proviso is to accept something out of an enactment. So those things are included here. Like holding subsidiary is included in the definition. It is included in that word company. Section 8 is also included in this word company, and companies incorporated under separate act, that is also included over here. So we are just trying to remove it from there with the help of a proviso. To accept something, accept means to qualify or remove. We are trying to qualify something which is stated in the enactment, that it will not apply to whatever is mentioned in the proviso. You are qualifying it. The effect of proviso is that it qualifies the enactment which is expressed in terms which are too general. Okay, general means they are applicable to many things. From there we are removing something, and that is proviso. To embrace, okay, to embrace the field covered by the main provision. What is an explanation? Sometimes we feel that the reader will not be able to understand the text properly. So there is an explanation. Like if you see the definition of holding and subsidiary, after that definition there is an explanation. We feel that those there are certain provisions, or there are certain words which may be confusing, so it is better that we give an explanation to the reader. This is appended. Appended means it is added at the end of the section to explain the meaning of the text of the section, to include or to exclude something from the section, to clear ambiguity, that is confusion in the main section. So you are trying to provide some explanation. Now I had mentioned that we are also going to read some text from my textbook. This is an extract from my textbook. Proviso is added to an enactment to qualify or to create an exception to what is an enactment. It is embedded in the main body, and from that main body, through the proviso, you are trying to remove it. If it is not removed, it will continue to remain an integral part of the enactment. The proviso starts with provided that the effect is to qualify the preceding enactment which is expressed in terms which are too general. So sometimes general terms, like we are using the word company, but from that we are excluding section 8 company, we are excluding holding and subsidiary company. It carves out an exception to the main provision. The cardinal rule of interpretation embraces the field which is covered in the main provision. Explanation: it is added. We have covered this. It is to be read in harmony so as to clear up the ambiguity. We feel that certain words, certain terms may not be clear. That is why we are clearing that with the help of an explanation. So this is something which you need to make note of, and I think you must have paused the video and written this in your notebook. Mr. R is an advocate. Okay, he has fraudulently deceived his client, Mr. Chandan, who was taking his expert advice on taxation matters. Mr. R is liable to a fine for his fraudulent act both under the Advocates Act as well as the Income Tax Act. State the provisions as to whether this offense is punishable under both the acts. Can you punish a person for the same offense twice? No, that's not possible. Now, he has committed a fraudulent act. You want to punish him under the Advocate Act as well as the Income Tax Act. No, he cannot be punished for the same offense. You have to decide whether you want to punish him under the Advocates Act or the Income Tax Act. All right. Where any act or omission constitutes as an offense in two or more enactments, then the offender is liable to be prosecuted and punished under either or any of those enactments. See, there is no specific English word either or any. Okay, there's no such phrase. Either Advocates Act or Income Tax Act. Okay, so either this or that. Either or any has no meaning only. Okay. So he will be liable to be punished either under the Advocates Act or under the Income Tax Act, but he will not be punished for the same offense twice. However, if he has committed a series of offenses, then yes, you may convict him for one offense in one act, other offense in the other act. That is possible. But he cannot be punished for the same offense twice. What is the meaning of the word commencement? Commence means to begin. Yes, commence means to begin. Okay. The term commencement is used with reference to an act or regulation, means the day on which the act or regulation comes into. So you must have read that the Contract Act came into force on 1st September 1872. So that is the date on which it comes into force. So commencement basically means to start. You can write it here. Commencement basically means to start or to come into force. To start or to come into force. It refers to the process by which the legislation and other legal instruments, they have legal effect. You cannot, the law cannot be said to be in force unless it is brought into operation by the legislative enactment or an exercise of any authority. Okay, that is not very important for us. What you need to understand is that the act will come into force on the day on which it is enforced. So you can say that the provisions of the act, they will they will start on the day that the act comes into force. So if the Indian Contract Act came into force on 1st September, it means that it applies to all the contracts which are entered after the first day of September. So legal force actually means the date on which it is operational. So it comes into operation, it comes into force. You can use that word. So it should not just be a theoretical implementation, but also practically, okay, it should come into force. What is the meaning of affidavit and what is good faith? See, good faith we have already covered. Now, what is the meaning of affidavit and what are the key words that you need to write in the exam? See, affidavit is basically self-declaration. I don't have documents supporting it, so I am declaring instead of swearing. No, no, oh, I swear, I swear. I don't know, this is oral. I want something in writing. So affidavit is some affirmation, confirmation given in writing, confirming that whatever is written on the document is true and accurate. So can I say that affidavit is nothing but an affirmation? It is a declaration given to the entire world. It's an affirmation. It's a declaration given to everyone that whatever is written in this document is true and accurate. I'm signing it, I'm writing it, I'm confirming it. That's an affidavit. You don't have any document supporting what you're saying, so you write it and you say that whatever I'm saying is true and accurate. I can sign and give it to you. This definition is inclusive because it says that affirmation, sorry, affidavit shall include. Okay, so it's an inclusive definition. Affidavit shall include affirmation, declaration in case of persons who are allowed by law to affirm or declare instead of swearing. So it's an inclusive definition. Affidavit will include affirmation, it will include declaration. It does not define affidavit. Is the word means written over there? No, it's inclusive. So affidavit is a written statement. Instead of taking an oath or swearing, it's a written statement. It has to be in writing. You cannot give just an oral affidavit. Okay, so the affidavit has to be in writing. It's a written document. It can be used as an evidence in the court of law. So it is a written document. It can be used as an evidence in the court of law. Mr. Sohan has issued a promissory note to Mohan on 17th of May, payable 3 months after date. Let us quickly find out the due date also. So it is issued on 17th May and it is payable 3 months. So after May we have June, July, August. So 17th of August, to this we will add 3 days of grace. So that comes to 18, 19, 20. So 20th of August. This is my due date. Let's confirm. Payable 3 months after that, a sudden holiday is declared on the 20th of August. All right. Due to which the courts are closed. So what is the date? And whether it should be 19th or it should be 21st of August. See, if a sudden holiday is declared, then it will be due on the day which is next. That is proceeding. Proceeding means 21st of August. What if it was a public holiday, like it was falling due on 15th of August? Then preceding, that is one day before. Section 10 provides that in case the courts are closed, etc., I cannot take action on that day, then the date on which the courts are open on the next day, that will be the due date. So here it will be considered as 21st of August. Insurance policy covering immovable property are also immovable. No. See, immovable has been very clearly defined to include land, any benefit arising out of land, anything attached to earth. But insurance policy is just a right. It's an agreement. It's a written document between the parties. So it is not considered as immovable property. So what is insurance policy? It is a written document. In fact, it is just an agreement between two parties. Okay, it is just an agreement between two parties. It is just some paper on which we are recording the terms of insurance. All right. So you can call it as a paper, as a document to record matter with respect to insurance. Insurance policy is a written document, all right, containing an agreement between the insurer and the insured. It includes matters which are intended to be used or which may be used for the purpose of recording. It's not covered under the definition of immovable property. This is very interesting, students. Please mark this as important. You need to go through this one day before the exam. The word bullocks could be interpreted to include cows. No, that's not the case. See, if you are using general terms, In case of general terms, yes, we can say that male includes female also. Like, for example, a general term, actor. So, actor will include male actor as well as female actor. But here they have not used a general term. They are saying bullocks. Okay. Bullocks will not be interpreted to include cows. Okay. So, yes, the word connoting stating a common gender, that we will say it includes male, includes female also, like actor, like chairman, it includes chairwoman also. But here they are very specifically mentioning bullocks, that will not include cows. Ajit was supposed to submit an appeal to High Court, but the court was closed. So we will again state the provisions of Section 10. Yes, Section 10, computation of time. You can present it on the next day on which the courts are open. So again, it's a repeat question. Vipul and Ayush are two friends while doing group studies. They are confused about the provisions of Section 3. They say that a company may be formed for any lawful purpose. They are confused whether it is written may, so is it mandatory or directory? See, the word may always shows discretion. The word shall, should, that shows mandatory. Okay. So the word may is always directory. The word shall is mandatory. It is compulsory. Okay, it has to be done. You can also say that the word may is enabling. It's enabling, it is directory, it's optional, it depends upon you. How will I understand whether it is mandatory or, discretionary? Just try to read it as it is. Just try to read. A company may be formed for lawful purpose. It means you can form a company for lawful or unlawful purpose. Is that what is the intention of law over here? No, 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 no. So, prima facie, the word may shows option. But if you feel that after reading the word and considering may as it is giving ambiguity. See, if I read the word may as it is over here, okay, if I read it as it is, what will happen? You may form a company for lawful purpose, you may form it for unlawful purpose. That's not the intention of law. So over here, even though the word used is may, you will read it and interpret as shall. You can read it and interpret as shall. Now try. Here the word may should be interpreted as mandatory. Only then it makes sense. The company should be formed for lawful purpose only. Yes, now it makes sense. So sometimes may will be read as shall. Here the word may should be read as shall. It shows mandatory, that the company has to comply with the provisions of Section 3. Sometimes may will be read as shall because it makes more sense. So if you use the word may and read the sentence as it is, it shows ambiguity. This was not the intention of lawmaker. Then in this case, may shall be read as shall. Okay? So may shall be read as shall. The word may is generally not mandatory. It's only directory or enabling. It is mandatory if the directory provisions are defeating the provisions of the. If I use the word may and read the sentence as it is, I don't think that is the intention of the lawmaker. So then you use the word and see if shall is making more sense. May and shall, they can be interpreted interchangeably depending upon the intention of the legislature. This is important. You need to write this in your answer. Here the word may shall be read as shall. This is also important. Here the usage of the word may makes it mandatory for the company. Okay. There are two ways to reach city A, roadways and waterways. How is the distance measured? On a straight line, straight plane, that is given in section 11. Yes, in the measurement of distance, The distance, unless a different intention appears, will be measured in a straight line on a horizontal plane. I will measure it in a straight line on a, I will not go like this, etc. The act done negligently shall be deemed to be done in good faith. You have to explain. So you just have to explain what is the meaning of the word good faith. Okay. Act done in good faith. Negligently. No, negligently will not be considered as good faith. Again, you have to consider the facts and circumstances of the case. Like, I was required to check certain documents before confirming the PO. I did not check, then that is not good faith. You can't say, oh, I'm so sorry, I was negligent. That's not good faith. Examine the validity of the following. The board of directors, they have passed a board resolution appointing 5 employees for the accounts department. Munim appointed 5 employees, including Mr. Rupal, who was a relative. 1 month after, Mr. Munim observed that Rupal was not performing his duties, so he wants to remove it. Mr. Rupal filed a petition that his dismissal is not valid, as the board had authorized Mr. Munim only for appointment of the employees. Are the main aim of the General Clauses Act is to shorten the language of law. How will you shorten the language of law? The person who has the right to appoint, they can remove, suspend also. So this is how we shorten the language of law. See, as per section 16, the authority which has the power to appoint will also have the authority. Now, what are the keywords? They will have the power to suspend or dismiss also. So if you have the power to make appointment, that same person, unless some different intention appears, will have the power to remove or suspend also. So in this case, the power to appoint includes the power to suspend and dismiss also. So Mr. Munim is correct. Okay. As per the mentioned section, it provides that the company is said to be a company in which the public is substantially interested if it is a company which is registered under section 25. Now, after the advent of the Companies Act 2013, corresponding change was not made. In the Income Tax Act, they are still using the 1956. So what should we consider, the 1956 Act or the 2013? It's only as a matter of reference. They must have forgotten to change. The 2013 Act only will apply. That is given in section 8. Now, every act has its own distinction, own uniqueness. If later on the act is merely making a reference to the former act, it is only by reference, and all the amendments, repeals in the new law will be in effect. So it simply says that if we are making a reference to the earlier law, it is just by reference. We will not consider that. In fact, the amendments and the repeals will be considered effective. That is mentioned in section 8, where the act or the central act made after the commencement repeals with or without modification, then reference is only as a means of reference unless a different intention appears. In Gauri Shankar Gaur versus State of UP, this is an important name. You need to learn the name. So over here, we are only making a reference. The provisions of the Companies Act 2013 will be applicable. The Ministry of Corporate Affairs, they published in the official gazette the proposed draft of the rules further to amend certain rules under the Companies Act. They made modifications. Is MCA required to publish a draft for the proposed rule? Yes. If you are making some changes, then you need to publish a draft. In case of irregularities, can the irregularities in the publication of the draft, can it be questioned? No. Now you must be wondering, ma'am, what are you writing? I'm not able to understand only. That is because, students, you need proper notes for that. See, all laws are not made by parliament. Okay, there are certain laws which are made by the local authorities, that is municipality. We give authority to make laws for their regulation to the local authority. These are known as bylaws. Like, you cannot spit, I will put 5,000 fine. Those rules can be made by the municipality or at the local level, local authority. Okay? Now, in case I want to make certain changes or I want to introduce something, we need to publish a draft of the proposed rules or bylaws for information of the persons likely to be affected. See, if you consider the example of ICAI, when they introduced the new scheme of education, okay, when the new scheme, did they one fine day announce that from tomorrow this new scheme will apply? No. They first prepared a draft. They gave it to people who are going to be affected. They asked them to make representation. See, if you're not happy, give your feedback. The publication, sorry, they then published it. They asked for feedback. Publication in the manner as prescribed by the government. This is just an example. ICI is just an example. You will also publish a notice along with the draft stating the date after which the draft will be taken into consideration. So you are just giving an indication that before this particular date, please give whatever representations or objections you have. It is all very logically connected. See, the local authority will prepare a and publish a draft. Where will it be published? It will be published in a manner as prescribed by the government. This publication will also be accompanied by a notice that mentioning that after this particular date the draft will be considered. The date, okay, now, but before this date the authority will also obtain sanction of any other authority required, take into consideration the objection or suggestion from any person. It's a very simple and logical flow. First is that you will publish it and give it to the people who are likely going to be affected by it. You will publish, how you will publish? In a manner prescribed by the government. Along with this, you will also publish a notice stating that after this we will consider the draft, so please give your representations before that. Then after the discussion, the rules or bylaws shall be published in the official gazette, and once they are published in the official gazette, it is a rule, it is understood that the rule or the bylaw means it is just like a law. Like I explained, local authority has made some law that no spitting in this area, person found guilty will be subject to 5,000 fine. This rule is applicable only in municipality of my area. So these are just like a law, they are bylaws. Now I had published the draft. Okay, then certain changes were made. After every change, do I need to keep on publishing it? No, that's not required. Once you have made the changes, you can directly finally publish the bylaw or the rule in the official gazette, and that is a conclusive evidence. It is conclusive proof that the rule or bylaw was made. Answering the question on the basis of this, is it required for MCA to publish a draft of the rules? Yes. In case of any irregularity, can it be questioned? Publication of the draft. Now, once it is published, it is a proof that the bylaw has come into existence. Before that, when it was in the draft stage, that time, yes, you can question it. Is MCA entitled to make suitable changes in the draft? Yes, why not? You can make, but before it is published. Huh? After it is published, then you cannot. Before publication. Publication means before it is final, that final thing is published. In the draft stage, you can make. Is it necessary to republish every kind of change? No. So over here, yes, MCA is required to publish a draft. No, in case of any irregularities, we cannot. Once it is published in the official gazette, once it becomes final, then you cannot question it. MCA can make changes, but before it is finally published, okay, it is not necessary to republish each and every change. Mrs. Neelu was a director in Laddu Sweets while dealing with the supplier of raw material, and she agreed to some secret commission. A case is filed against her. She is stating section 166 that a director of the company shall not achieve or attempt to achieve any undue gain or advantage, and if he is found guilty, then they will be liable to make compensation. She is claiming that I am a female and that section does not apply to me. Male includes female also. Just like singular includes plural, section 13 says that in all the central acts, okay, if there is nothing repugnant, means if there is nothing contrary, okay, if there is nothing repugnant means contrary. Unless there is something repugnant, the words importing the masculine gender will include female gender also. So over here, according to section 166, it is not applicable, not only applicable to the males, but also to females. Therefore, she is not correct, she is bound to comply with section 160. So that is my conclusion, that she is bound to comply. And I think with this, yes, we also come to an end of our discussion. I hope you were able to understand. In case you have not written this, you can now please make a note of it. Okay. So these are the various steps. Go through it. We had discussed this during the lecture also. So students, I hope you got a fair idea of what kind of questions can be asked from this chapter and which sections are more important. If you would like to discuss the entire syllabus with me, then do visit my website capreetyagarwal.com. This is a lecture of my series of question answer discussion from my compiler book. Compiler is nothing but a compilation of all the past exam questions, study material, RTP, MTP questions arranged unit wise. That book and this can be these lectures can be purchased from my website capreetyagarwal.com.